Pablo Ibáñez Colomo, very warm welcome to Digital Markets Research Hub. I was looking forward for this conversation for quite a long time. I know your career and yourself for more than 10 years. I remember how you joined the UI as a PhD researcher and how huge waves emerged immediately, how you brought new ideas from College of Europe and beyond. And it was really a lovely time. And since then, you are a prominent academic at the London School of Economics and Political Sciences. And it's really a pleasure to have this conversation with you. Also, obviously, edit this trendsetting blog jointly with Alfonso Lamadrid, Chilean Competition, and many other projects which would be quite time-consuming to even to mention. And among other things, you have published your second major monograph, The New EU Competition Law. So I propose maybe we can start this conversation with the most obvious thing. Maybe I have several questions about this book, but let us start with the motivation.
Great. No, thanks, Solis. By the way, I'm really excited to be here. As you say, we've known each other for quite some time. We started our projects, I think, on similar legal issues, and I'm really glad that we've kept in touch. And I'm really impressed to see your progress. And I think what you've created with this hub, among other big projects, I was really looking forward to this chat. And thanks so much for mentioning the book, right? So then I'm in sort of book launch mood, etc. I've had some events and so on. So then it's something that, as you can imagine, is dear to my heart, is the latest project. And one likes to believe the latest project is the best one, but still the best is just to come. So I think it's the right time for us to have a conversation about this. And I think, given the nature of this project of yours, I think it makes sense to start with the book, right? For the simple reason that the key motivation, going back to your question, is precisely to give an account of how competition law was changing, right? If one looks at textbooks, for instance, well, textbooks are incremental by definition. And that means that it is difficult for them to capture change or to place the emphasis on what is changing and how competition law is changing, right? So then by definition, a textbook is a child of stability. So then I wanted to do something that is not accurately captured in textbooks, not because textbooks are bad, simply because textbooks are a different animal, and something that would complement individual articles as well, right? So then in a way, as I mentioned in chapter 1 of the book, the whole idea was to focus on the moving object, right? So then on the aspects of competition law that are undergoing change and the new features of the system that were not part of it in the preceding incarnations, right? So that was the original motivation. And it's very closely linked to my teaching as well, right? So in a sense, I had an advanced competition law module, and I told myself, well, if I want to prepare my students in the best way possible, what I have to do is expose them to change, right? Expose them to some extent to the frontiers of knowledge. And in a sense, that meant telling them competition law is undergoing changes, and here's how I understand these changes. So we can have a conversation about exactly those aspects that did not feature in the traditional incarnation of competition law.
And you, by the way, in the introduction, you express very warm gratitude to your students, undergraduate and postgraduate students, and it's really noticing very remarkably, maybe obviously for many, but not many dare to articulate it for themselves and let alone for others, that teaching is very academically rewarded exercise, which helps you to practice, to mature, to refine the ideas. And only after you have tested this, play ping pong with your students and talk for hours on the subject, you can write them in a more approachable but very condensed and refined fashion. So I think it's another excellent observation. But speaking of the book itself, what do you think? You somehow mentioned the trend that competition law was developing linearly, but now with regulating network industries and digital markets, competition law in the broader sense of the term we made a kind of jump. We see two types of competition law, more policy driven, the current one, and more law oriented. But you offer much more sophisticated and much more nuanced taxonomy. Maybe you can reflect on this kind of matrix of how you define different benchmarks.
Right, and I think that's a good point, right? So then how I typically present the ongoing transformation is along three axes, right? So then there's a change that is institutional in nature that came with the adoption of Regulation 1. And the adoption of Regulation 1 essentially meant that the Commission was given greater freedom to decide which cases to investigate, right? So in a way, the burdens of the notification system, of exemptions and so on, that was left behind, and that meant that the Commission could make use of its limited resources in a more effective way. So that's one change, and that was reflected in a number of ways. But I think one of the transformations that I address in the book is the shift from law-driven enforcement to policy-driven enforcement. And if you look back to the white paper of '99, etc., I think one of the points that the Commission emphasized at the time is, well, we have developed a competition law culture in Europe. It is not our role to make law, or our primary role from now on is not going to be that of clarifying the law to stakeholders, because there's sufficient case law, there's sufficient administrative practice. So from now on, we're going to make use of our resources to make policy rather than to clarify the status from a legal perspective of some practices. So that's one key transformation. I think the symbol of this transformation, but definitely not the only one, is the commitment decision. And that's something that even surprised some, at least officials at the time. Well, the prominence that commitment decisions acquire in the system is something that was not necessarily anticipated, but I think captures very well this institutional transformation, whereby enforcement became policy-driven and attaining policy outcomes became, so to speak, the key force underpinning the Commission's activity. There's also an economic transformation, right? I think it has to do with what you mentioned, digital markets, network industries, and so on. And that economic transformation meant that the traditional tools of enforcement were not simply adequate in the new system, right? So then the traditional tools of competition law, the sort of reactive enforcement, as I call it, the use of cease and desist orders and so on, well, that works very well in oligopolistic scenarios, right? What we might call the industrial era, right? What was the new economy back in the 1960s, right? So the chemical industry, steel, and so on. Well, those industries tend towards oligopoly. And in those industries, the traditional incarnation of competition law works very well. It's something that can handle the issues, and a negative obligation administered on a one-off basis, that works very well. Then enter the digital era, and that doesn't work anymore. And the same is true with network industries, right? So network industries were regulated because they revolved around natural monopolies. At least one segment across the value chain was a natural monopoly. And the moment you have a natural monopoly, the traditional tools don't work anymore. So then this was realized in relation to energy and telecommunications early on. A new form of enforcement had to come into play. Otherwise, enforcement would simply not be effective. So you need positive obligations. You need obligations that are administered on a repeated basis and so on. And that meant that you needed new tools. You needed a new form of competition law, what I call market shaping competition law. And digital markets, on which you've done extensive and admirable research, I think is pretty much the same thing, right? Essentially, some segments across the digital value chain present the same characteristics. And the moment you have to deal with a bottleneck, that is to say, with a segment of the value chain that has a natural tendency towards a monopoly or towards a quasi-monopoly, then you need new tools. You need the sort of tools that you see typically in economic regulation, that is to say, access obligation, rate setting, and so on. So then in a way, the economic transformation meant that new tools or new remedies were required. And it was not a capricious thing. It was a function of the features of those markets. And then you have, thirdly, the third axis is the intellectual transformation of competition law, right? So we saw, and I think probably when we were studying at the EUI, the two of us, it was the high point of the more economics-based approach. The more economics-based approach had its critics, it has always had its critics, but I think when we were doing our PhD, I think it was the point where we thought it would sweep the whole system, right? And from then on, we've seen a progressive decline of the more economics-based approach. We've seen new concerns. We see some old ideas being resurrected, some new concerns relating to digital markets being raised. And in that new intellectual climate, we also see new attitudes to enforcement. We see also more receptiveness vis-a-vis the application of competition tools to exploitative abuses and so on. We see the rise of fairness and all sorts of other things. So then once you combine the institutional change that allowed the Commission to be bolder and to be more selective in the use of its resources, the economic transformation that meant that new tools were required, and then the intellectual transformation, well, you get an incarnation of competition law that differs very significantly, not only from the one that we saw was going to be the end of history when we were doing our PhD, but also the enforcement that we saw in the 70s and the 80s.
Amazing. Several questions emerge out of this exposition, and the first one probably the shortest and the most technical. The role of commitment you mentioned, embodying the trend. The DMA, the original proposal did contain the mechanism of commitment. Now it has been shrinked only for systematic non-compliance. Is it against the rationale of kind of more dialogical modality envisaged in the DMA would probably nurture the more active use of commitment and maybe also shifting the main proposed remedies from the enforcer to the gatekeeper, or it's rather immaterial and the mechanism of commitment is de facto embedded in the mechanism of regulatory dialogue or specification decision?
Yeah, I think the spirit is very much the same, right? And I think if any way, I mean, and that is something I mentioned in the book. I don't mention the book for the pleasure of mentioning that, right? Simply just to give your listeners an idea of what the book is all about. But I think at chapter 5 of the book discusses whether and to what extent the DMA is the end game of the new competition law. So you take all these three trends together, the intellectual, the institutional, and the economic transformation, and where those trends lead you is towards something that looks like the DMA, right? So then in a way, if you like, is the logical evolution of the trends underpinning the rise of commitment decisions, right? So it's not quite a commitment decision, but if you look at Article 8, how it's designed and what it's intended to do within the whole DMA, I mean, the conclusion that one inevitably draws, I think, is that the spirit is exactly the same, that the DMA is designed to promote dialogue and to avoid as much as possible the adoption of formal decisions, right? So then the commitment decision is a formal decision. So in that sense, there's a difference, but the underlying trend is the same, right? So we move towards some sort of regulatory dialogue and permanent regulatory dialogue that is, I think, in spirit is not fundamentally different from the spirit of the commitment decision, but if you like, it takes it to a new level. It takes it to the next level whereby this regulatory dialogue can happen by and large in the absence of any sort of formal decision.
And we can see that the DMA as a continuation or embodiment of this trend, but we hear this constant, continuous discussions that DMA is not competition law, casuistic, scholastic. We understand that it's done by the same people, but at least, and inspired by the same rationale and vision. But do you think that there are some elements in this new policy-driven vision which require different skills and different perception of the role and mission and mandate of competition policy in the broader sense from the enforcer themselves? Do you have Is it good that the DMA is being enforced by the same people, or it requires more regulation? So is DigiConnect necessary addendum to this effective enforcement, or it's something which can be done by the DigiComp itself, or maybe broader strategic steering from somebody else?
I think that's good. And then, I mean, many questions. I would say, first of all, adopting formal regulation in this particular context, I think it was a logical move. And I would say it was a desirable move in a number of ways, right? Because when you have this sort of enforcement, market shaping enforcement, whenever competition law more generally mimics economic regulation, competition law suffers, right? So then competition law is not designed to apply on a permanent basis, on a continuous basis, the sort of remedies that we see in sector-specific regulation. Every now and then, competition law can impose an access obligation. Every now and then, competition law can give it a go at exploitative pricing and so on. But for competition law to assume on a regular basis the role and function of a utilities regulator is not something that works, and I don't think it's desirable. Right? So then, in a way, the DMA is an acknowledgement of that. Right? And it's not a criticism of competition law. Competition law is an incredibly effective tool. It can improve citizens' lives in a number of ways, I think quite remarkably. But when competition law is required to do certain things on a continuous basis, competition law will fail. Right? So then, in that sense, it's reasonable to adopt the DMA, and it's reasonable for competition law to adopt a different role, which is not that of doing the heavy lifting when it comes to digital markets, right? So having said that, I think, and you mentioned the question of expertise, I think it goes along the same lines, right? Competition authorities cannot do this on a continuous basis, and I don't think it is reasonable to expect, or is even fair on competition authorities to expect them to behave as utilities regulators on a permanent basis. And this is where I think it's only reasonable to have DigiConnect, because they have the expertise and they have been handling similar issues in relation to telecommunications market, right? So then sort of bringing that expertise together and combining the expertise of DigiComp and DigiConnect is only logical. And I would say it's desirable, if only insofar as it's an acknowledgement that competition law will be stretched too much if it were to handle or to do alone the role of a utilities regulator on a permanent basis.
And in the book itself, one part of the book is case studies where you talk about network industries, and also you put them in a kind of chronological reflection of this new coexistent vision of policy-driven competition law. I wanted to ask you, what are the differences between the DMA and the previous phase? Are there systemic differences which we have to be mindful of? Is it just a kind of a variation of liberalization policy from early 2000?
Right, no, thanks. A great question. And I think a very important one. So I think there has been big transformations, I think, from the time of the liberalization process and the DMA. I think one key difference, I would say, I think in terms of the vision and the understanding of the role of regulation has to do, and I wonder the extent you agree with me, is a different vision in terms of how much the legislature trusted markets, right? So if you look at the liberalization package, I think underpinning those packages, I think there was big trust on the market, right? So then the moment regulation does its job and creates the appropriate condition for competition to flourish, the market would deliver, right? So then underpinning, for instance, the telecoms regime, and a very central, in fact, to the telecoms regime was this idea that competition is the best form of regulation. This is reflected in a number of ways, but I think one of the key manifestations of this idea is that the telecoms regime was designed to shrink over time. The understanding being that once you create the right conditions, once you regulate in the right way, regulation can roll back. And we can trust competition to do the job of regulators. So there was this big trust in the market system that was at the heart of all of these regimes, right? So that the extent to which they deliver, well, that's a different story. So for instance, we saw in energy, in electricity, etc., well, the success is perhaps not as big or as noticeable as it has been in telecommunications, but that's a different story. Underpinning all this regime, there's big trust in the market. I think the DMA distrusts the market much more than the liberalization regimes. So then, and it's interesting, right? Because I think you would have thought that trust in the market would have been more acute in an industry that has developed without any sort of government assistance, that has developed or that has flourished without any subsidies and so on. Whereas the opposite is true, right? So then, in a way, the DMA distrusts the market much more. So then, at a high level, this is a difference that I see, and it's quite important. When it comes to the legislative choices that have been made, and we have to the choice of the tools, and so on, this is also reflected in a way, or in a significant way. Take the telecoms regime, for instance. One of the things that you realize is that it's sort of built around competition law concepts, and that regulation had a role that was very clearly defined. What do I mean by that? That regulation would only apply for as long as certain clearly defined parameters would justify intervention. The moment those parameters would tell us, well, regulation is no longer justified, we can roll back regulation, regulation had to roll back, right? So then intervention, so to speak, was the exception under the telecoms regime rather than the rule. And there was no, I mean, another mantra in the telecoms regime was this idea of no regulation for the sake of regulation. So as an authority would have to make a case as to why in a particular context intervention was necessary. None of that is true under the DMA, right? So then the DMA doesn't have a cutoff date. The DMA doesn't have clearly defined mechanisms to roll back regulation, which is not to say that the possibility of rolling back regulation does not exist, as you know. So then the designation may become, then an undertaking or a gatekeeper may no longer designate it as such. If the market evolves in a particular direction, there's a chance, or there's other review mechanisms and so on. But those review mechanisms are not as clear cut, and they do not see intervention as the exception rather than the rule. So in a way, the spirit of the DMA is to say, well, we're going to intervene for as long as necessary, and we're not going, so to speak, to apologize for intervening. And that's a key difference in a sense, right? So then if you take the telecoms regime, the moment the incumbent is no longer dominant or no longer holds a position of significant market power, regulation would roll back. And the criteria to determine whether or not an incumbent has significant market power were very clearly defined. None of that is true under the DMA, right? So the DMA, the message I get from the DMA, well, we're in this for the long haul, and we're not going to rush when rolling back regulation. So in a way, the message is, or I think the perception I get from the regulation is that perhaps the legislature believes that they took too long to intervene, and then the message is, well, and then we're not going to rush to roll back regulation. And regulation is going to happen for as long as we believe it's necessary.
And then one of the features of the DMA, this opacity by design, given or significant scope of discretionary mandate to the enforcers, and for good or for bad reasons, I think that's the only way to do meaningful, to shape, as using your vocabulary, to shape competition in digital markets. But the question which preoccupies me in this regard is, where do they have to take the inspiration? Because this fairness and contestability, as well as the very substance, however clearly defined the obligations themselves are, we understand that compliance can have several layers, and you can turn a blind eye, say, okay, you complied, okay, particularly the role of third parties is rather reduced. Private enforcement might be another backdoor, but assuming that it will not play prominent role as standalone, at least in standalone basis, the Commission does have discretion, and the room for interpretation in this open-ended digital landscape is quite wide. So they must be driven by some broader goals. Should they just sense these goals? Should they know them? Should they share these goals with us?
Right. I think it's a big experiment, right? And it's a big experiment on a number of fronts, because the question is, well, you need some goals. But what makes the DMA even more interesting is that it's not even clear whether, even if you've defined your goals, whether the DMA can deliver. And let me be clear, this is not a criticism in any way, right? So then I can understand the reasons why. I think the push towards the adoption of sector-specific regulation in digital markets was very strong, and one can understand the reasons why there was such a big push to adopt this regulation. But I think the open question here is that it is not even clear whether the DMA can deliver, right? So before we start talking about the goals, I mean, something that was quite interesting, a notable difference between, say, liberalization in telecoms and energy, or transport for that matter, and digital, is that if you take telecoms, well, the most sophisticated, if you like, of all network industries, the problems and the solutions were very well understood, right? So then after all, if you take telecoms, it all boils down to two key issues: access to the local loop, access to the natural monopoly, and interconnection. And then those problems were understood, and how to address those problems was also relatively well understood. So when it comes to the DMA, I think it's fair to say, and you probably agree with me, that these markets are orders of magnitude more complex, right? And the dynamics are more complex, right? So then what is behind Google's dominance? Is it the data? Is it the handling of the data? Is it consumer lock-in and so on? So there's a number of issues, right? So then even assuming that your goals are clearly defined, the question is, well, can you achieve contestability, right? So because it's very ambitious if you think about it. So then contestability means that, well, at least in some segments that have a natural tendency to monopoly or quasi-monopoly, you're going to take action in order to inject rivalry where none existed, or in order to sustain rivalry where none existed. That is incredibly ambitious. But again, if the market has a natural tendency towards monopoly, will it happen? Will contestability happen? We don't really know, right? So it's an experiment. And I think I'm sympathetic to the people that said, well, whether we can make it or not, that's not a reason not to intervene. So I can understand why some people might say, well, it might not happen, but we have to try. Or the economic power of these gatekeepers have become so entrenched that not doing anything is not a solution. So we might succeed or not succeed, but we have to do something. Then that's quite interesting. But I think, of course, the bottom line is that it might not deliver, right? So when it comes to the objectives and how it is guided, again, I think the experimental nature of the DMA comes to the fore once again, right? And how do we define fairness and contestability? In the telecoms regime, well, whether you're dominant or not is a dividing line. There was a clear dividing line about the success of the regime. And the moment the incumbent is no longer dominant, we can call it a success and we roll back. Enter the DMA, fairness and contestability. When is a market fair enough? When is it contestable enough for us to come to the conclusion that the gatekeeper is complying with the obligations? Well, as you say, we don't really know, right? So then there's no clear dividing line. There's no clear boundary such as dominance in the DMA. So then a lot of that is going to be learning by doing. And I think to some extent, and I think because of what you mentioned, because in effect, Articles 5, 6, 7, and in particular 8, give the power to the Commission essentially to decide whether or not a gatekeeper is complying with the obligations. I think the Commission will have to learn by doing and decide when it is satisfied. And of course, because there's no clear boundaries, because the lines are not defined, it will be difficult to say. So then I fully see why you are raising this question. Well, we don't really know how to draw the line or when I mean, on the basis of what criteria we can say that a market has become contestable enough for us to roll back the obligations. I think it will be a lot of learning by doing and a lot of expectation management as well for the Commission. And that's the other side, right? It's not only about whether or not gatekeepers comply, but about managing the expectations of other stakeholders, right? Be it sort of business users who would benefit or who benefit from the DMA, and also governments who might say, well, this is not enough, etc. So then it will be, then with discretion, I think discretion comes with pluses, but of course it also comes with minuses from the perspective of an authority, because that means that you will have to manage expectations and justify vis-a-vis those benefiting from intervention why you're drawing the line at a particular point or why you're not pushing for more. Right? But I think there's a lot of learning by doing, but I think in a way that was the understanding, right? So that was the conception. Let's experiment. Let's not be discouraged by the fact that this might not even work to begin with, and let's see how far or what we can do in relation to these markets.
I personally see it as a very risky feature, but not a bug. It's a feature intentionally. We decided to play this risky game as the only option left to do some meaningful changes, full of vagueness and Machiavellian or Jesuitic type of approach. I normatively endorse it, but I acknowledge that it's just the beginning of the story, and it will we leave this open question as open, and I hope we'll have a chance to reflect upon it in some time in the future. But during this DMA negotiations, you have articulated quite a few purely juristic specificities of the new regime. And one of the features which you also reflect in the book is that, and I quote, there is another factor that may make judicial review, we will talk about judicial review in the next chapter of our conversation, less likely. The DMA allows the Commission to exercise its discretion in a way that avoids the adoption of formal decisions, thereby minimizing the chances of direct action. So can you elaborate? It's quite self-evident what you have said, but do you think, again, is it on purpose? And what will be the implications? Will the court still find a way to constrain, to narrow down this scope of discretion?
Great point. I think I fully agree with you that it's deliberate, right? So then the DMA was designed to minimize judicial intervention, and that's not a criticism, right? So it's a legitimate design. So there's democratically elected bodies have made a choice. The choice was to allow the Commission to maximize the scope for the Commission to achieve the objectives of the regime. And it has done that, I think, in a number of ways. And then Article 8, and I wonder whether you agree with me, if you read carefully Article 8, I think the conclusion one draws is that the Commission is under no duty to adopt a formal decision once, of course, the undertaking has been designated as a gatekeeper. But if you read Article 8, there's a number of routes available to the gatekeeper. There's a number of routes for the Commission to give clarity. But I think the overarching conclusion one draws from Article 8 is that it has been carefully crafted so that the Commission will never have to adopt a formal decision on compliance with Articles 5 to 7. That's the outstanding feature. And I think that's very much in line, going back to one of your questions, with what we discussed before about policy-driven enforcement, about maximizing the scope for intervention by the authority, right? So then one question about judicial intervention is whether the Commission will adopt a formal decision. And I think that was a key factor, right? So then one aspect to consider is whether the Commission will go down the road of a formal decision. I would say, or my impression, looking back at how the Commission has behaved over time, is that the Commission will be extremely reluctant to adopt a formal decision on compliance with Articles 5 to 7. Right? So we read the Regulation 1, the Commission had a preference for commitment decisions, which do not rule on the substance. The Commission has never adopted, as you know, an Article 10 decision within the meaning of Regulation 1. declaring that a particular practice is compatible with Articles 101, 102, or fulfills the condition of Articles 101.3. So if we look at how the Commission has behaved, I think the impression one gets, I think if one were to bet about future behavior, is that the Commission will be extremely reluctant to adopt a formal decision in compliance with Articles 5 to 7, right? But of course, it's not the only player in the system. The other players in the system are gatekeepers. So then are gatekeepers going to play ball? So the preliminary conclusion we draw from what we've seen so far is that clearly some gatekeepers are willing to play ball. Other gatekeepers might actually fight harder to get closer to their vision, or to minimize the extent to which the DMA transforms their ecosystems and so on. But it remains to be seen how much some of the gatekeepers will push the envelope, right? And one question, I think another factor to consider is that also by design, the DMA is sort of carefully crafted to induce compliance by gatekeepers, right? So there's a number of instruments the Commission has from a procedural standpoint to sort of ensure that gatekeepers comply with their obligations, right? But perhaps some gatekeepers might say, well, rather than coming to a mutually acceptable solution through regulatory dialogue with the Commission, we want the court to be involved. That's perhaps, and then maybe, we don't know, maybe we'll reach a point where the Commission will have to adopt a formal decision, and then the EU courts will become involved in interpreting the DMA, right? So that's a question, right? But how much or how involved will they be? And again, I think it's difficult to say, but I think is one arena where I don't see them becoming very involved again because of a design made by democratically elected bodies. I think this is a factor to consider whenever we speculate about whether and to what extent courts will become involved in the interpretation of legal provisions.
And this leads us perfectly to your article published in Cambridge Yearbook of European Legal Studies, Law Policy Expertise, Hallmarks of Effective Judicial Review in EU Competition Law. Remarkable piece. I really enjoyed reading it and rereading it while preparing for this conversation. You articulate quite a few very, very important elements. Some of them we have addressed already, the relationship between competition law and competition policy. But maybe we can start this part by just reminding to us how much competences and how much appetite do the European courts have in terms of clarifying the provisions of competition, ex post competition law, and maybe we can extrapolate to the DMA.
Yes, I mean, how much appetite? Well, I think what seems clear to me, and I think we've had some judgment not only in relation to ex post competition law, but also in relation to merger control, where I think the EU courts have always been clear that their role is to interpret the scope of competition law provisions and EU law at large, right? So then how roles are defined by virtue of the EU treaties is very clear that it is for the courts to define what the law is and to clarify the meaning of the law. And this has been a constant in a number of ways. And if we think about the case law, for instance, on restrictions by object, the court has not hesitated to annul Commission decisions whenever it believed or it concluded that it sort of deviated from the right interpretation of Article 101.1 and so on. If we think of merger control, it was even more acute, right? So if you read carefully CK Telecoms, so the appeal judgment in CK Telecoms, at some point the court reminds the European Commission that it is not for it to define key concepts in merger control, like closeness of competition, like maverick firm, and so on. These are issues of law, and it is for the court to interpret that. So then in one of the pleas you would remember in CK Telecoms, the Commission, and again, I don't think it's unreasonable, right? I can see where the Commission is coming from. was saying, well, it is for me to define what closeness of competition means, right? And the court reminds the commission, well, to the extent that this is an issue of law, it is for me to interpret that. So then call it appetite or call it something else. I think if we look at the case law across the board, it's very clear that I think the EU courts have been faithful to their mission, which is that of the interpretation of the scope of competition law provision. So then in some cases, it has become more noticeable, say, for instance, in Intel and so on, where I think it clarified an aspect of Article 2 in relation to restrictions by object. One can clearly see a friction between the interpretation given, in some cases, by the Commission, the interpretation given by the courts, and so on. But overall, I think it's quite clear. And I think, if anything, CK Telecoms, even though you could see the appeal judgment in CK Telecoms as endorsing some of the key claims made by the Commission. So in some ways, I think the courts showed that it was sensitive to some of the issues raised by the Commission. On the other hand, when it comes to the question you raised about their role when it in relation to the interpretation of competition law provisions, I think the court was quite clear on that front.
And if you look at the not ambition, but the perception of EU competition law and the DMA maybe in the future by the judges, do they think they have in mind a broader political vision, objectives, or do they interpret their mandate of interpreting the law narrowly? Do they look at cases exclusively without trying to somehow in a Dworkian way to filter the political morality qua the main meta objectives of society through their own perception of what is better for this society, and to interpret these provisions and scrutinize the case and adjudicate on the case, bearing in mind this broader societal geo-economic context? Or it's something which blurs the clarity and they try to do it in a more syllogistic way? Or is it a combination of both, or there's some other ingredients are missing maybe?
Yeah, nothing. I mean, it's always difficult, right? Then I joined the CAT back in June of last year, so I haven't been involved in any case so far. But the conclusion I get, I mean, when chatting with judges, and some of them are really inspiring, and I think something that I really appreciate about the EU courts, both the General Court and the European Court of Justice, is how seriously they take their role and how deeply they understand the role of the system and how seriously they take it. And then secondly, how intellectual they are, right? Then I mean, I'm privileged to have met a number of référendaires, have more sort of sparingly met some of the judges, etc. And some of the things something that strikes me every time is how intellectual they are, right? How seriously they take scholarship, etc. There's a tradition in Europe about that, right? So then how sort of they want to understand the law of the real issues, and how they appreciate the job done by those experts who take the time to read and to analyze and to systematize, etc. So then how intellectual they are. A number of référendaires, or many référendaires actually, they have PhD in law, and I think there was a tradition as well, even from some professeurs agrégés from French universities, to spend some time at the court, etc. So then that aspect is quite notable, and I think provides an answer to that. So that's part of the story, etc. Then I think something that is notable, I think when one thinks of the differences between judges in the US and in the EU, I think something that strikes me is that EU judges understand the role as part of a broader system, right? And I think that becomes very clear, right? So there's no disparity of visions and so on, right? So you understand the role within the EU, and they see themselves as actors within the EU and with the aims and objectives that the EU seeks to achieve. So that's also quite clear, right? In the US, you might see some conflict because those philosophical visions are describing become more apparent, etc. I don't see any of that. I think in Europe, I think it's narrower in a sense. I mean, as far as I can see, in the sense that I say, well, we're players in an organization, a sui generis organization that is called the EU, and we have to play a role in the system. So there's an understanding in that. But I think the last point I would mention, the one conclusion I've always drawn in my conversations with judges or référendaires, etc., is that deep down they know they have to give an answer to the issues raised in a particular case. And this is by and large how they see their role. I don't know the extent to you agree with me, etc. But I think, I mean, this is what I find interesting chatting with them, on exchanging views with them, because I think the two of us would be more naturally inclined to think in terms of a system, I think bringing us together, etc. But I think it's very useful for me to have conversations with judges and référendaires, because I get the acute sense every time that the role is above all to give an answer to a particular dispute in a particular context. So then, and this is what is going to drive by and large all of this. And if we see the trend, I would say, of the past 20 years and so, I think it's quite acute that I think the ACJ says, well, the system is built, right? So in a way, I mean, mutatis mutandis, what we were discussing in relation to the Commission on Regulation 1 back in 99, I think I get the sense, well, the building is there, so then the foundations are there, so then we can now behave as a court in any other legal order, which is one that is within the system that has already been set up, the foundations of which are already in place. We can sort of focus on addressing the issues raised by individual cases. So, I mean, of course, it's inevitable that, I mean, broader considerations, right? But I think the one refreshing conclusion, or the one refreshing sort of takeaway every time I discuss with it is exactly that one. That above all, they see the role as, well, giving an answer to the dispute in a particular case. But of course, the EU judges are also aware, and I think it's a pleasure to listen to Judge Kuhn-Lennartz every time. And I think the one conclusion I draw whenever I listen to Judge Kuhn-Lennartz is that if the president understands very well and is acutely aware of the role of the European Court of Justice in the system as a whole.
You started your new role as a member of Competition Appeal Tribunal in the UK, and for this reason, I think it would not be appropriate for me to ask specific questions on the emergent still regime, Digital Markets, Competition and Consumers still bill. I wanted maybe in the future we will have chance to discuss it in more detail with other peers, but I wanted maybe to ask you more general and only question in this regard. Do you think it's better to, if you have this ambitious mandate or vision to start shaping competition in digital markets, is it better to start as to shape it as a new start, as DMA, distancing yourself from good and bad experience of ex post competition law, or rather as a continuation, as an improvement, as a 2.0 version of ex post competition law, even if this clear-cut discretionary mechanism, but still positioning it as a competition law, or it depends?
Yeah, the thing, I mean, it takes me back to some extent to one of the points I made before, right? So then overstretching competition law is a bad idea, and it's a recipe for frustration, and is a recipe ultimately for inaction. So that's the conclusion I drew, right? So then the criticisms I've seen of competition law in the past few years, before the adoption of the DMA, competition law being too slow, competition law not delivering, and so on, I think is a frustration that comes from the fact that competition law was expected to do something that it was not designed to do. It was never designed to do, and it will fail at doing. So that, I mean, if only because of that, I think a fresh start is necessary, right? I think it's also important to adopt a formal regime, in my view. I think it's a better strategy to adopt a formal regime, because I think hangovers are likely to otherwise influence the process, right? So then the moment we say we're going to reshape digital markets, we know that competition law, from our experience in other systems, including in telecoms, cannot do certain things on a continuous basis. Well, let's start with something that is ad hoc, that is sector specific, and so on. It's always better. And then along the same lines, then defining the DMA along or on the basis of objectives that are not competition law objectives, that you say, well, we're going to be guided by fairness and contestability as opposed to something else, I think it's a better idea. I think there's no reason why competition law should define the boundaries of economic regulation. I think nobody would agree with that. The telecoms regime, for instance, was designed to do something that competition law was not designed to do. Under the telecoms regime, dominant positions were a problem, whereas a dominant position is not a problem under competition law. Something similar happens with the DMA. And I think that is quite natural from my perspective. And rather than pretending that one is applying competition law in the usual sense, I think it's better in every way. For competition law and for the success of the other regime to have a clean break and to stop pretending that we're applying competition law, although we're applying a new version of competition law that differs from the outset, right? So then this has a number of consequences, including about the role of judges, etc. But I think if one were to make a choice, I think a clear cut, and I think it's always better from my perspective, for the integrity of the competition law system and for the success of the new regime.
Let us move to the last part of our conversation, namely academic life. We work in UK academia, and you started your career as a lecturer and a professor at LSE 15 years ago almost. And you obviously had a conversation with senior, more experienced colleagues in the past. So you have a clear understanding of the development and the functioning of UK academia, and coming from the continent, you also know the functioning, and you can compare, at least maybe sporadically, it with continentals, if such single system exists, maybe some member states. What do you think about this trend? I have also another question about the difference in mental kind of learning from College of Europe kind of type of legal thinkers and EUI type of legal thinkers. But the first one is more related to the evolution of UK academia.
Well, the evolution, we have to be incredibly grateful. I think you agree with me about UK academia. I think it has given me a career that I don't think would have been possible in my home country or in many other countries in Europe, right? Then it has the flexibility and the autonomy given to individual institutions that I think allows us to flourish, etc. Then there's an ecosystem that is quite unique. And I think it's the degree of autonomy probably that makes all the difference, right? So when I think of other systems, what I think there's an ambition towards homogeneity, etc. There's good intentions, etc. But I think if there's something that we've realized, I think not only in relation to higher education, but also at the level of primary education and so on. I don't know if you've following the PISA evaluations by the OECD, etc. The one conclusion I think we draw systematically is that giving autonomy to individual centers tends to be associated with better outcomes, right? And it is exactly that that I think is one of the key reasons behind the success of UK academia, the fact that it punches above its weight, so to speak, and has done so for a number of years. And I remember when I came for my interview, etc., everything was relatively informal, and the LSE had the full autonomy to develop its mechanisms when it comes to appointments, development of career, etc. And I think that's something that has always struck me. And if I were to think of differences across other regimes, I think that would be the key aspect that would stand out. I think that's one difference. And I think another difference I would say is that how much sort of entrepreneurship and independence is encouraged, right? Then what I like about UK academia is it's very horizontal. I never felt there was a hierarchy, and I always felt I could sort of explore my path without much guidance. I was incredibly fortunate to have a mentor, and I think that's a key aspect of LSE that I think has played a role in the development of my career. So I had the current dean at LSE Law School, David Kershaw, who was appointed as my mentor when I joined LSE. So having a mentor, having a reference is always very important. So then mentors quickly evolve as role models, as has happened in my case with David Kershaw, with Heike Schweitzer, and so on. But on the other hand, so then mentorship is good, but the fact that I was not directed in any way, that I was allowed to follow my path, I think this is something that I value incredibly. I didn't have to engage in particular lines of research. I was given a good sense, and I didn't know much about UK academia when I came, about how my career might evolve, etc. But I could follow my path by and large. And this takes me perhaps to the third feature of UK academia that I value enormously, that it rewards effort in a sense, right? So then there was this autonomy, there was this freedom that I was given, but within the confines of the freedom that I was given, I was rewarded because I had become, or my research and my sort of profile overall has become that of a professor, and I was rewarded sort of promptly, I have to say. I'm incredibly grateful for that as well, right? So then that combination, I think, is what makes perhaps UK academia quite special, and what makes, I think, that explains why I think some of the institutions have such profile around the world. And you probably agree with me. I think that you've probably experienced the same.
Absolutely, I fully agree, Pablo. The last question before asking to provide recommendations to students is stereotypical. You have encyclopedic knowledge of case law, and stereotypically one would infer it to the way how it's been done in College of Europe on both campuses. One can already probably conclude. Whereas in the UI, another stereotype is kind of peripatetic, walking, you go indiscriminately in the different classes, just trying to cherry pick and do this kind of cocktail, unique, and then come up with some original high risk, high return ideas, etc. I know it's cliche, and there is probably something in it, maybe not. You've had the privilege to graduate from both institutions. You teach now in College of Europe, you observe the trend. Is it true? To what extent?
No, that's a good point. And then what we have to understand about the College of Europe, I'm incredibly grateful to the College of Europe, but again, is a very unique institution born out of very particular circumstances. But the College of Europe was designed to be a training school for people who would become sort of civil servants within European institutions. Now it has a much broader remit, etc. Is no longer accurate, but it's shaped in the mold of similar institutions in France, like the École Nationale d'Administration, Sciences Po, places like that, right? Where I think teaching is at the front, and where teaching is not done by full-time faculty, as you would have in the UK and in the US, but rather by people who are exposed to practice. And I think I'm incredibly grateful for my exposure to that way of looking at legal issues, because it complemented very well what I learned on the EUI. Right. So then what the College of Europe gave me, and this is by and large thanks to my friendship and the infinite conversation I had with Denis Walbrook, who was also a professor at the College of Europe at the ULB, but was also a practitioner. I think they made me understand how important it is, even as a researcher, to do or to work on issues that are relevant in practice, right? So this sense that as legal scholars, we are privileged, but we have to give something back to society, right? And so the sense that whatever it is that we do has to have some relevance. It doesn't have to be policy driven. It doesn't have to be policy recommendations. Most of the stuff that I do, if not all of the stuff that I do, is positive in nature. I'm not in the business of recommending or proposing changes and so on. But on the other hand, I think they instilled in me this sense that working on stuff that is relevant and bearing in mind that whatever it is that we do as scholars has to bear a relationship with the real world, I think is quite important, right? So then bearing in mind, being aware of who it is that is taking those decisions, bearing in mind that so there's individuals taking those decisions. Right, so that's quite important in my view, right? I think, and going back on the cliche, I think that you're mentioning, is a conversation I had with some people from the College of Europe, right? So then I was shocked when I was exposed to some research on EU institutions, etc. And I think the immediate reaction I had is to say, well, they're dealing with people as if they were abstractions, right? So you cannot examine or study, say, the European Court of Justice, the European Commission, etc., without bearing in mind that they are human beings, right? And that they are there's people who are under enormous pressure to take decisions, who may do things, who may get things right or wrong in particular instances, etc. But you also have to bear in mind that they're human beings, right? The thing, and once you are at the College of Europe, you understand that because you are exposed to these people. And the people I teach at the College of Europe in a few years will be working at the European Commission, DG Com. Some of them will go to the court as référendaire. So then it may sound overly simple, right? But I mean, this awareness is quite important. And the impression I got is that more theoretical scholars, right, they're so detached from that reality that it necessarily has an impact on the research that they do. So it's not only that they forget that they're dealing with human beings, but that necessarily such high level of abstraction loses nuances in that sense. So then I'm very grateful for that. But I'm also very grateful, I mean, to have been exposed to the EUI because I think, as I say, the College of Europe was conceived primarily as a teaching school. Research came thanks to the impetus of two people, Paul Desmarais, who was the rector at the time of the College of Europe, Inge Govare, who was the director of legal studies, right? So they're trying to push towards increased research. I benefited enormously from that. So then how they changed sort of the mission of the College of Europe and to inject research and so on. But it was growing at the time, right? And the EUI sort of exposed me to more systematic research and to people who were devoting their lives to research, right? Whereas most of the College of Europe, the full-time academics was pretty much us academic assistants, right? Which is great in a number of ways, right? We are exposed, we're encouraged to pursue our path, and we can make of our job as junior academics at the College of Europe whatever it is that we want to make of that. So that freedom is great. But of course, some guidance eventually becomes necessary. At 25, 26, 27, and there's a lot of stuff that we don't know, as you can imagine.
Pablo, I wanted also to ask you at the end, what recommendations would you give to our students, and maybe reflecting among other things, how you read cases, how do you build links between such lengthy texts, complex texts, and there are so many. Maybe some life hacks, maybe some tips on this, but maybe also broader
Great.
recommendations.
No, sounds very good. I can be relatively brief on that, right? So then first point, write a lot. So then don't delay writing. So then drafting is an essential part of being an academic. So then the easiest part is to do research, to collect cases and so on. But I think one aspect that I think has helped me enormously is to draft and think and to work on my texts early on. That's helped me enormously when I was at the College of Europe, helped me enormously at the UI. So then it is only by writing, by sort of building the bridge between the ideas you have in mind and sort of the concrete expression of these ideas in writing that makes all the difference. And I think for junior academics, it's always a challenge, right? I think and start writing, and the more you write, the better you write, as you know, etc. So that's one key aspect. Something that I wish I had done more is to share your work widely, right? So then combine the drafting early on with discussing ideas with more senior scholars, right? So then the sense I get is that perhaps if I had not rushed some publications so much, I think they would have been better. And this is an aspect that I think benefits enormously. And again, as I was telling you, there is a lot of stuff that you don't know when you're 25, 26, 27. There's limited time that we all have, etc. So sharing your ideas widely with people outside the competition law world, I think benefits enormously. So then one thing that I would like to do more in the coming years is to exchange views more with administrative lawyers more broadly. So people like Joana Mendes, etc., who will provide insights I haven't heard, right? So then another dear friend of mine from the LSE, Eduardo Baistrogi, he's a tax lawyer. But by talking with him, I think we have benefited enormously from our conversation, right? So then share ideas widely in a raw form, etc., that benefits enormously, right? And I think the third point, I mean, perhaps I think it's important at this stage, right? An academic is not an activist, right? So then I would say don't get drawn into activism as an academic, right? So then we all have ideas, we all have preferences, whether we express them or not, whether we sort of try to keep them out of our writing, or whether the front and center of our writing. But I think it is a pity that we live in a world in which sort of the role of the activist is becoming very attractive. And I can see how young academics may become drawn into that. Rather than, I would say, as a third point, is that you're an academic after all, and the role of an academic is different from that of an activist. So you can conduct two lives if you like. That I think, as a piece of scholarship, is not a pamphlet, so to speak. It's something else. And it is about sort of understanding. I mean, this is at least my understanding of academia, is about understanding the world around you. And it is not about sort of pushing for change. That's something that I would say for junior academics is quite, because I think activists are noisy, they're attractive, they get traction and so on. So I can see why that is true. But I mean, at the end of the day, I think the work of a scholar, the work of an activist is quite different. And I'm not judging, right? So then these are two perfectly respectable missions, etc. But I think conflicting the two or pretending one is the other, I think is something that might cost a junior academic further down the line.
You mentioned among these recommendations, which I appreciate very much, one which we somehow tend to forget, and this is a side effect of deeper and deeper compartmentalization and working in the niches, because so much is going on, you become narrow and narrow and expert, that we less and less, we do attend research staff seminars, learning about other areas of law. But you mentioned that you communicate and get inspiration and somehow mentorship in terms of scrutinizing the maybe formal aspects of the depth of argumentation or the structure of your argumentation from peers who specialize in other areas of law, knowing nothing about the substance of the topic which you examine in your research. Do you think we are losing this intradisciplinary multi-loc with other peers who do, how much we can learn from each other? Is it is there, because I think economists, for example, they have common denominator, they have clear-cut taxonomy of what is a reputable publication, and when you in law, I start noticing that we are less and less intercommunicate with each other. Is it a problem? Is it inevitable side effect of specialism?
Yeah, I don't think it's a problem across the board, right? So then, for instance, at the LSE Law School, one of the traditions we have, and I think what keeps the law school together as well, is that we have these staff seminars every Wednesday. And it is, well, as a colleague of mine or a PhD student presenting. And it's an incredibly rewarding exercise because you get a lot of feedback from that. So then, in a way, I've never abandoned that. I mean, if only because perhaps I've always had interest in other areas of the law. So I'm working now on state aid issues. I'm working now on other issues. And I always like to look elsewhere. But I think, I mean, let me put it this way. It's absolutely crucial. Whenever we spent a lot of time talking about discretion, administrative discretion, about judicial review in this chat. I try to read as much as I can about those issues outside of competition law. So then it's quite important. I think you can count that as a fourth piece of advice, at least for those who choose to work on competition law matters, is that competition law is rudimentary at a theoretical level in many ways, right? And this is why some relatively sort of basic errors are made in scholarship precisely because of that, because we lack the foundations in other fronts, right? So then I would say it's absolutely essential. I would say, I mean, not to praise myself, is simply because of how I grew as a scholar and so on, that I think comes naturally to me. So then I'm very interested, I think deep down what I'm working on, and you sort of detected that, and I could clearly see that through our conversation. I'm interested in how administrative authorities exercise their power, and about the relationship between judges and administrative authorities. I mean, that is the core of my work, right? I happen to know more about competition law stuff, etc. But because I see that as the overarching theme of my work, I typically read elsewhere. And I've read fascinating stuff on administrative law, on judicial review, etc. that was completely outside of the competition law world. So then I would say, I mean, we could be doing more. to sort of nurture that. I think hyper specialization can become a problem. There's some people now that I say, no, I only work on Article 102 and Article 101, right? And then, I mean, that's becoming a problem, right? But then if you don't look elsewhere, and if you don't take a broader perspective on your work, I think your work will inevitably be poorer, right? So then if I'm working on some issues, I mean, very often the most influential pieces of research that I've read were not competition law pieces at all, right? So some of the really ambitious, sophisticated scholarship done on administrative law by people like Matthew Stevenson from Harvard Law School, etc. Those have shaped my thinking much more than a lot of the stuff that I've read on competition law.
Pablo Ibáñez Colomo, thank you very much indeed for this fascinating conversation. It was an absolute pleasure for me.
Likewise.